Rule 7, the parts and contents of a pleading. Section 1, the caption. The caption sets forth the name of the court, the title of the action, and the docket number if it is already assigned and raffled to the particular court. The title of the action indicates the names of the parties, and they shall all be named in the original complaint or petition. But in subsequent pleadings, it shall be sufficient if the name of the first party on each side be stated with an appropriate indication when there are other parties. So, in the original complaint or petition, all of the names of the parties shall be indicated. But for subsequent ones, we can use the first name of the party and then include the words et al. Okay, their respective participation in the case shall also be indicated. Example, Juan de la Cruz, plaintiff, represented by Pedro San Juan, lawyer for the plaintiff, and so on. Section 2 is the body. The body of the pleading set forth its designation, the allegations of the parties' claims or defenses, the relief prayed for, and the date of the pleading. Its paragraphs, the allegations in the body of a pleading shall be divided into paragraphs so numbered as to be readily identified, each of which shall contain a statement of a single set of circumstances so far as that can be done with convenience. A paragraph may be referred to by its numbers in all its succeeding pleadings. This is done for convenience, so that they can be readily identified, so that when the defendant answers, he may specifically deny the specific paragraph set forth in the complaint when it is numbered. Okay, so the headings: when there are two or more causes of actions that are joined, the statements of the first shall be prefaced with the words first cause of action, and the second by the phrase second cause of action, and so on for the others. When one or more paragraphs in the answer are addressed to one of several causes of action in the complaint, they shall be prefaced by the words answer to the first cause of action or answer to the second cause of action, and so on. When one or more paragraphs of the answer are addressed to several causes of action, they shall be prefaced by words to that effect. Third paragraph is the relief. So the pleading shall specify the relief sought, but it may add a general prayer for such further or other relief as may be deemed just and equitable. Of course, the date must be included in the pleading. Okay, section 3, the signature and address. So every pleading and other written submissions to the court must be signed by the party or his counsel representing him or her. The signature of the counsel constitutes a certificate by him that he has read the pleading and the document, and that to the best of his knowledge, information, and belief formed after an inquiry reasonable under the circumstances, that it is not. So this is the importance of the signature of the lawyer. We have to take note first that it is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2. That the claims, defenses, and other legal contentions are warranted by existing law or jurisprudence, or by non-frivolous argument for extending, modifying, or reversing existing jurisprudence. Third, that the factual contentions have evidentiary support, if specifically so identified, will likely have evidentiary support after availment of the modes of discovery under these rules. And lastly, that the denials of factual contentions are warranted on the evidence, or if specifically so identified, are reasonably based on belief or lack of information. Okay, next. So if the court determines on motion or motu proprio and after notice and hearing that this rule has been violated, it may impose an appropriate sanction or refer such violation to the proper office for disciplinary action on any attorney, law firm, or any party that violated the rule or is responsible for the violation. Absent exceptional circumstances, a law firm shall be held jointly and severally liable for violation committed by its partner, associate, or employee. The sanction may include but shall not be limited to non-monetary directive or sanction, an order to pay a penalty in court, or if imposed on motion and warranted for effective deterrence, an order directing payment to the movant or part of all of the reasonable attorney's fees and other expenses directly resulting from the violation, including attorney's fees for the filing of the motion for sanction. The lawyer or law firm cannot pass on the monetary penalty